Can you still succeed in a UK visa application if you have previously been refused entry into the UK? One question that keeps bothering past and future applicants is whether one can still succeed in a UK visa application if they were previously refused a visa to the country or were granted but refused entry upon arrival at the airport. So, why does a visa application get refused? Is the refusal the end of the road? Why will an immigration officer refuse entry and cancel a visa? And how do you get it right on the next try? Join Charles Asma, lawyer of BWF Solicitors, and our host Oreku Owusu on the Saturday, 4th of February 2023 at 4 p.m. on the Community and the Law program on BWTV and BW Radio as he discusses how to improve your chances of obtaining a UK visa after a previous refusal. Call. Join us live and the radio and TV discussion on BW Radio and BW TV on 0044 7399 208 468 or 0044 208 123 1016. WhatsApp 0044 7950 422 780. The Community and the Law live on BWTV and BW Radio. Brought to you by BWF Solicitors, your preferred community lawyers.
Jesus, you're my everything, yeah. My everything is you, Lord. Yeah. Oh, 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 oh. Everybody say, ah. How can I express my gratitude for all the many things you've done for me? Words are not enough, enough to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things you've Father, you done for me, yeah. Lord, you are, you're my everything. See, I call you Jireh. Lord, my provider. I call you Eunice. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are, you're my everything. I call you Jireh.
Hello, good afternoon to all of you out there. It's another wonderful Saturday afternoon, and we have had the privilege to put together something real good, something spectacularly exciting for you to enjoy between now and 6 p.m. here in the UK. My name is Oreku Owusu, and I'm welcoming you to another edition of the Community and the Law. The Community and the Law is a program that brings you every bit of discussion when it comes to the law, especially here in the UK, when it comes to nationality, when it comes to family, and the other bits of what it is that you need to know when it comes to marriage, divorce, relationships, your ability to stay in this country legally, and the rest of it. Those of you outside of the UK and you want to come in here today, I have a very interesting discussion to go on with you. Can I still succeed in my UK visa application? have once been refused entry into this country? I think the answer is yes. Why that? Lawyer tells us my guest and the resource person from BWF Solicitors will be on hand to deliver the answer. So stick and stay, don't go anywhere. Invite somebody to join you. Tell the other person to tell the other person, and to tell the other person that we are live. And we live on BWTV, BW Radio, live on BWF Solicitors Facebook page, BWF Solicitors YouTube, and all the social media platforms. Once again, welcome to another edition of The Community and the Law. TikTok, the clock ticks away. We have counted another 7 days into the year and into the month of February 2023. My name is Ulriko Frimpon, and I'm welcoming you to another edition of the Community and the Law program. It comes your way every Saturday afternoon between 4 and 6 p.m. UK time. Today, we are here with a very interesting discussion, and I want to tell you that when we pick up our topics and we do our research and all the other bits in preparation, we go to the doorstep of BWF Solicitors and we'll put that there before them and ask them the question. Now, today the question I'm asking is a very interesting one, and it is this: can I still succeed in my UK visa application if I've once been refused entry into this country? So, answer it for me, Lawyer Charles Asma, and he's going to do that. So let's put that to BWF Solicitors, and we'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law: family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we'll get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Your trusted legal partners are BWF Solicitors. They do everything for you when it comes to the law. So Monday to Friday between 9:30 and 6 p.m. Please visit them on the 4th floor of the house, and you will never regret you did. Go in there, the typical Ghanaian Kwaba and welcome waits you. It's the only law firm I can say and confidently say that you served something Ghanaian and you have your Ghana chocolate definitely when you go there. So when you tell them, I say you should have it. In any case, let's say thank you to them and also commend them that they always come our way and answer our questions for us. And today, as I've already said, Can I still succeed in my UK visa application if I've once been refused entry into the UK? The answer is, well, that's coming up. So I want you to stay with me throughout the program. Now, you can send in your question and your concerns to our text line 07950422780. Or you can call in when the lines are activated, and you can call us on 07399208468, 07399208468, or the landline 0208 1231016. Once I've done this house duties, let me also give you the numbers for BWF Solicitors. So when it is that you have to contact them, it would not be a difficult thing to do. 0208 493 7340, 0208 493 7340. BWF Solicitors are trusted legal partners. And today, I should tell you something. On Monday, they released this information to the domain, and we are here to really read that one out and let you know what it is that you have to learn. Now, it's talking about evidential flexibility. Now, evidential flexibility, what does it mean? It is it is when an application is made to the Home Office and there are gaps in the evidence. It is a Home Office's responsibility to ask for more information and documentation to fill in the gaps. These allow decision makers to be more pragmatic about evidence gaps. Caseworkers will engage with applicants and provide them a reasonable chance to submit further documentation to fix any obvious omissions. This is discretionary. Thus, if they refuse the application without giving you the chance to address the evidence gap, you can bring an action against them. This is a case of Turner and others, and it's something that was ruled way back in 2014. So it's been there, and obviously, if you didn't know, we're telling you now. They're saying that if there is evidential flexibility, it means that when application is made to the Home Office and there are gaps in the evidence, the Home Office has the responsibility to ask for more information or documentation to fill the gaps. What may those be, and how we're going to address that? Before then, let me go to my gentleman of the afternoon friend, um, my trusted friend, my legal friend, my learned friend, my guest for today. BWF Solicitors is where he works, and he is my resource person for today. Lawyer Charles Asma. Uncle Charles, good afternoon.
Good afternoon, Brother Cook.
How are you?
Pleasure being here. I'm all right.
Well, good. Well, the weather is getting mild, not too cold. So I'm excitedly happy because I don't like the cold. Sometimes when it's so cold, I want to go back to Ghana.
Away from the cold. Gradually getting there very soon.
I so much love. Sometimes February is a bit very cold, but when it's getting to the middle of February and you get into March, where the spring is springing on us, obviously I get excited because I don't get too cold and I don't need to put the heater on because it's too hot. In any case, well, we deal with nationality, we deal with issues that allow people to legally stay in the UK. And today, one question I'm asking is, if, for instance, I send any documents to the Home Office and by dint of human nature, or maybe I don't have those documents at hand, so the fullness of the requirement I do not meet, do I have any opportunity for them to give me a chance to bring in those things? I think that's about what Aneget is talking about.
Yes, we will offer our greetings to viewers and listeners. So we go straight into the nugget. Just as you said, will I have the opportunity to? And case law, one of which has been cited, the case of Sultan and others, this is a 2014 case. There are also other cases, the case of Rodriguez and also the case of Mandelia. They all point to the same fact that Home Office has a policy to be flexible. And the policy says that where there is minor omission of evidence, the caseworker must be flexible to exercise discretion to give opportunity for that applicant to provide or literally to fill in gap.
Mhm.
So the question is, how wide is the gap?
Okay.
So evidential flexibility, actual opportunity given to the applicant by the caseworker within the framework of law and also the caseworking guidance and policy to say that, yes, you've missed A, but you have to provide. But we are talking about whether you've missed A entirely or you've missed part of A.
Okay.
And A refers to the evidence. And the evidence are the supporting document you need to support your application.
Okay.
So the question here is, how much discretion should the caseworker exercise?
Mm.
And if the discretion is not exercised, does that give the applicant opportunity to seek redress in law at court?
Okay.
The position is that yes, the discretion must be exercised fairly and reasonably.
Mhm.
However, that discretion or evidential flexibility opportunity does not replace specific evidence or specified evidence provision. So if there is specified evidence, what are we talking about? We are talking about what you need to support your application.
Mhm.
So if you are making a student visa application, you need to support your application. If you are making appendix FM application, you need to support your application. If you are making 10-year, 2.5, and a 10-year rule, you have to support your application. If it is direct access, you have to support it.
Mhm.
So let's assume that you are making an application under direct access rules.
Okay.
You have to show that you have a child, don't you? Based on whom you are making the
The
application.
application. All right.
Because it's not about partner, but your child. So if you don't bring anything about your child, should the caseworker give you opportunity to bring that which you should have brought? So that is what we're asking as how much discretion
Okay.
and whether the discretion replaces the specified evidence framework.
But you're talking about how much? Okay. For instance, if I have to provide my personal identity and they're requesting 3 different types of ID documentation, and I'm able to provide 2. In that case, would the caseworker allow me to bring the third one when I have it? Because probably at the time that I was submitting, I did not. And I might have given um, a reason in, say, a call letter that I have to add this, but it's yet to arrive in my post, and I'll bring it when it is. Would that give me the chance of
So in
caseworker
this
allow me
case,
to do that?
flexibility will allow you to provide because you've already hinted that you will do so.
Okay.
But we are looking at a classic example where you are supposed to provide, let's say, pay slips
Right.
to show that you the maintenance or financial threshold. You are supposed to provide bank statement.
Mhm.
You are supposed to provide accommodation evidence and all that. Now, you've provided all the things they've asked for, but maybe you are for one of them, you are supposed to provide maybe 5
Pieces
of them,
of it.
pieces of them,
Mhm.
or 6 or 10 or number of pieces of them. You've provided in your mind, you've provided all of them. But human beings as we are, you might have omitted one.
Okay.
So if you are supposed to provide, let's say 6 or 10, and you provide 9, thinking that you have provided all the 6, is it fair to be given opportunity to provide the one that is missing? So that is fair. That is reasonable.
That's
And
reasonable.
if they don't, then they have not been flexible enough.
Would you be justified to bring a case against them when you think that they have not been flexible?
So if it's a minor omission and they have not exercised the discretion, flexibility, evidential flexibility, discretion to ask you for it, then that is where we say that no, they have not been fair and reasonable in their assessment of evidence or in their application of evidential flexibility. We are saying it's a discretion. That means they can do it or not. However, if they don't, you can challenge them at court. Now, why is it that they should do it or they can do it, but they chose the one that favors and not the applicant. So the question here for viewers is this: are we looking at caseworker to tell us that you should have brought X, Y, Z, so bring them now, or you should have brought X and XA, but you brought X, you forgot XA, so bring the XA. That means in your mind, you provided X, just that the A bit was missing. It's a minor omission, isn't it? But if X is completely missing, would that be a minor omission or omission?
It could not be that.
Okay, let's put deliberate aside. Will it be a minor or major omission?
Well, it'll be a major omission of
But why will it be a major omission? Then you know that you should have brought this and you didn't. Then we say it's deliberate because you knew the checklist.
So in that case, then it is a mandatory refusal.
Then in that case, you have not met the requirements.
Right.
So the caseworker will not exercise discretion to say, go and bring the bank statement, go and bring this, go and bring this, go and bring that. More or less, they are telling you what to do. So what we are saying is that evidential flexibility has not replaced entirely the duty to provide specified evidence to support your application. However, where a specified evidence is provided, but there is a minor omission to provide all within that category of evidence, then within that category of evidence, if one is missing or two are missing, then you can be asked to bring them because we treat that as minor omission.
Well, folks, the body of knowledge is we built in, and we have added something today, evidential flexibility. And what it means and what there is to do is what Lawyer Charles Asma has graciously given us. So with that, let me go back to do a traditional thing and our welcomes. And I want to recognize the presence of so many other people who have joined us apart from myself and my wonderful friend Charles Asma. Boa Naomi here. Good evening, family. Hope everyone is doing well. We have good evening, everyone. Please share. Ademo Kum is doing that and asking us to do that. Odesheba Nana May today are there and Nike. Good evening, all. Thank you for your message. Odesheba, yes. Good evening, guys. I've got your message. Have Tilly Duma. Hello, lovely family. Tilly is asking all the other bits and other people to join us. Najima, senior minister, the class is ongoing. Please come on board. Mentioning names and recognizing everybody is what Tilly is doing. Margaret Edumensa, good evening, all you say. And then we have Kwabena. Tilly, please share. Yes, thank you very much, Tilly. I think I need to give you a prize today. You're doing all the work for me. We have Kwabena Tufuo. Kwabena Tufuo, you're watching. Where are you watching us from? If you could let us know, that would be wonderful. Boapunsem, you're watching. And also to Dr. Let's see, what Dr. Tina Rice Sachs. Oh, that's quite a good name. Good evening, everyone. Doctor, thank you very much for watching us on YouTube. Thank you. Coming up to 4 years, we recognized you, Doctor, and all the other bits. So what you need to do, when you come and you join us, please, 1, like the page, 2, subscribe to the notification so that every time that we put any content on, you will be notified. And 3, when you do that, you have the benefit of also joining our family and joining our class. It's a very exciting class every time we come on, and definitely you will be part of the family. Then again, you also have the responsibility to invite other people to come and join. It boosts the algorithm and also makes us bigger and better, so people will enjoy the information we send out. So ladies and gentlemen, thank you very much for being here, and I'm going to go into discussion straight away. Let me once again recognize that we have our lines that we use for the program. The text is 07950422780. You can send in your text or your WhatsApp message through to that line. Then you can call in on 0208-123-1016 or 07399-208-468. Now, the question and the topic I'm bringing on now today is this: can I still succeed. In my UK visa application, if I've once been refused entry into the UK, whether as a visitor or as a family member or a business person, whatever, when I am refused, what are the repercussions and what are the implications? Can I remember any situation that made me uh, susceptible to being refused? And I know Dr. Charles Aswa, yeah, I've given you a title. Dr. Charles Aswa is going to really help us unravel this. Now, when this topic was put out, many people called me, oh, I'm really interested in this. I'm really interested. Anybody that called me and said you're interested and you're not on board live now, I'm in trouble with you because I may refuse to answer your questions when it is that you ask me later on, because the answers are here. And by courtesy of BWF Solicitors, ladies and gentlemen, I introduce Charles Asma to help with that. Lawyer, good afternoon once again.
Good afternoon, Brako.
Thank you. I know many people, if my statistics would be right, 40% of people who put in applications to visit or enter the UK are either refused for one reason or the other. Now, when it does happen, people think that when you go in again, it's a bigger fish to fry. So people tend not to do that again. But the question is, can they try? Would they be allowed to enter when a thing is refused?
Yes. And by the time we finish with our discussion, one, we will know that the answer is yes. And two, we'll appreciate the exceptions.
Okay.
Or it is yes, but might not be yes under all circumstances.
Right.
And that's where the exceptions will come in. But generally, the answer is yes. Being refused is not the end of the matter. Being refused doesn't mean that you are forever denied. There's better tomorrow. So viewers and listeners, once again, it's a pleasure to come your way. You are here with us on the Community and the Law program this Saturday afternoon. Today, as the host has already introduced, we are looking at very pertinent point. And the point is that if I'm refused, what do I do? Is that the end for me? And we say that no, it's not the end for you, and that is the hope we offer you. However, there are exceptions, and therefore, by the time we finish the conversation, you will look at your peculiar circumstance and fit yourself into the framework of the opinion we have expressed today. Now, the first point I want to make is that every decision is made or every application is assessed on its own merit. So there is what we call meritorious assessment of application. And if the application is open to grant, it will be granted. If it is open to refusal, it will be refused. It doesn't mean that it takes what we call preemptive or it takes a retrospective reference. The fact that you've been refused before doesn't mean that they will go back and say you've been refused before, unless the current decision is peculiar to the previous decision made about your application. And we'll point that out so that people can draw the distinction.
You say each application is peculiar and decided on its own merit. But when you are completing the form, you are sometimes asked whether you've been refused before to any country. And does that not give an indication that it could be referred to?
The rules do not say that previous application decisions will be pertinent in the present application decision.
Okay.
And I say this with a proviso. The proviso is that if the decision is so grievous, the past decision is so grievous, then the current decision will make reference to it. We'll come to that, but let me just point it out that imagine somebody has been refused on a point of misrepresentation, falsehood, and that has triggered paragraph 9 or part 9 of the immigration rules decision to ban the person for 10 years. Then the rule will trigger another rule. The rule is that if you have been refused on the basis of misrepresentation of evidence,
Okay.
and you couldn't challenge it, and therefore it's on file, you cannot be allowed to enter the UK for 10 years. That will be stated in your refusal. And therefore, if you have already been given previously that you will be restricted for 10 years because of that, and you are making an application within that 10 years, is the decision preemptive? Yes.
Obviously.
Because they say that because of that, any application you make may be refused
Within 10 years.
within the 10 years. So you don't need any special scientific analysis to conclude that this is happening.
Okay.
And that's the exception. That's why I said that there are exceptions. And this is the only exception that we need to point out.
Okay.
Yes.
Now let's go through why refused, and what to do next.
And what to do next. Okay. So every application will be decided based on the rules, the policy guidance. So the Home Office will have a framework, and that framework cuts across all its case working decisions, be it in country or out of country. They go by the same guidelines. So you have made an application. Let's take a simple example of visit visa.
Okay.
The rules are that you make application to visit the country. However, you have to prove that you will return. How do I prove it? Apart from what I say. And it's a very high level or high threshold discretion. So if a discretion is exercised to refuse you, what the person is saying is that we don't think if you go, you will come back. It doesn't say that you are banned from doing it again. So if your circumstance has changed, then you can try again.
Okay.
And when you are trying again, it's always important to address the reason for the first refusal and what you've done about it this time, making this application different from the one that was refused. Otherwise, then what's the difference? So it's your case to always make sure that you go a step ahead to preempt what they are likely to say because you have history with them, and deal with that history and tell them this is what you said, this is what it is now, and therefore the application should be granted for X and Y reasons.
Okay.
Now, so there's eligibility requirements.
Okay.
Example, financial requirement, relationship requirement, maintenance requirement, accommodation, depending on what it is, and all that. So each application has its own requirement, or what we call eligibility requirement. We are not even going to suitability requirements. We are looking at the general principle that if you meet the rules, you should be granted. And the rules apply to any other application. It's up to you to check the application you are making and the rules that apply. Because the rules are not set in stone to be applied generally. So specific to specific application. So if you are making your application, you ask yourself, am I eligible? If you are eligible, you check the checklist for eligibility, the criteria. Once you have all the boxes ticked off, each box must be supported by evidence, what we call the supporting document. Then you send your application to the caseworker by clicking to submit online.
Okay.
Now, the caseworker will take and make assessment based on the evidence you have provided to support it. If the caseworker feels that the evidence do not, or the checklists are not met, then they will refuse. So if you look back, every application that is decided, they will give you a letter to say that you've been granted and this is why you are granted. Or a letter to say you've been refused and why you are refused.
Okay.
If you are refused, they will tell you are refused because you do not meet the eligibility requirement for XYZ for this application because you said this, but this is what it is, and therefore it is.
So for every application, whatever decision that's made on there's a reason attached to it.
There is a reason
Okay.
for refusing or for granting
Okay.
application, or for making that decision.
So then it goes to reason that if I apply as a visitor and I have been given the reason that the caseworker does not believe that I will return, if I have evidence that I will return, I can make a fresh application and answer the question.
And answer that question
Okay.
to prove that, yes, I have been able to prove that I can. But you see, with visit is just like somebody visiting your home,
Mm-hmm.
and you have a reason to say no to the person. You will find a reason.
Okay.
It's my home. If I don't want you to come in, I will have a reason to excuse to say no. We call it excuse.
Mm-hmm.
I'll have an excuse to say no.
Right.
Oh, I'm not available. Oh, I'm doing a renovation. Oh, I'm traveling. Oh, this or that. You have an excuse. So if the caseworker feels that on that occasion you are not to enter, they will have a reason to say no. And because it's discretionary visit visa application, you cannot even have right of appeal or administrative review. And that is why if your case is strong in your view, you'll be able to prove it, you put in a fresh application. And the next thing is that the application is likely not to be reviewed or decided the second time by the same person.
Mm-hmm.
On a balance of probability, it's likely to be somebody else. And everybody will have their own judgment and application of the policy guidance.
No, then it makes it tricky to just go by the blank principle that if they ask you a question or accuse you based on the reason, you can answer the question and you are likely to succeed. You might want to polish your application again rather than answering the question.
So if I say answer the question, obviously you answer the question within your application.
Right. Anyway.
So you make application, and this time not just submit the application, but seek to address. So people will add supporting letter. They call it cover letters.
Mm-hmm.
People will use the box, additional information box, to address the point for earlier refusal and why that point is covered this time and why they will come back, supported by evidence.
Mm. Do the caseworkers often suspect that once somebody is refused, they're coming back? And there's the chance and the probability that the same application will come before the person?
Well, I mean, we cannot really tell whether it will come back. But for me, it doesn't really matter who decides, makes the decision on the application. The key thing is that you have sought to meet the criteria.
Okay.
And seeking to meet criteria means that point one says, what shows that you will come back? What ties you have in the country in which you live to suggest that because of this, there's no way I will forfeit to stay over there. Are you a student? Then why will you forfeit your education? Are you a husband, wife, looking after family? Why will you forfeit your family in the large scheme of things?
Okay.
Are you a minister of religion? Are you a worker, so to speak? You are working. You are in gainful employment. You are working. Why will you abandon work to come and wander about, so to speak? So within the large scheme of things, they want to see how committed are you, to the extent that you will not relinquish that responsibility to stay here when you come,
Okay.
or to stay away. So you have to put in place all the things to show them that, yes, this person is actually busy. There's no way they will waste time. And therefore, if they are going on holiday as they claim, then it's true they are going on holiday.
I have been refused a visa of entry. At that time, I was a student. Now I am working in a reputable organization that I would really need to go back. Probably I need to somewhere rest and clear my mind and come back. Now, I was refused as a student. I come in as a worker with much more ties and responsibilities. You say every application is decided on merit.
Exactly.
But if I stated that 2 years ago I was a student, this year I am a worker, wouldn't it trigger any link to the previous one? And if it does, wouldn't the caseworker have some suspicion that this person at all costs wants to come into the UK?
I would say no, because this person made the application as a student. Maybe at the time, the person was even about to complete the course.
Yeah.
And therefore, they thought that if you're about to complete the course and you say you are going on holiday, you will return to continue education, then the point is not strong enough.
Okay.
Now they have completed the course. They have sought employment. They are in gainful employment. They might even have a family. So even greater responsibility and commitment. So the reason for traveling is not I will and come back. Your returnability test will be different.
Okay.
The returnability test for students is that I will come and continue my education. Returnability test for a worker is that I'm on leave for a short period. I'll return to continue. I'm even working on a project that requires my attention. There's a letter from employer to support the fact that I'm going on short holiday and all that. And therefore, I have evidence to suggest that the job I'm doing is lucrative enough not to be abandoned. You put in all this, there's no, well, I won't say there's no way. On a balance, it's likely the caseworker will agree with you that you come back to continue your employment. So that is one side or one example. Another example is that, yes, you made an application and you were refused. Let's say, as a EU spouse, or as a EU child, or as a EU mother, you were refused for whatever reason. It could be the reason that there was no adequate accommodation. Could be any other reason they cite. Now, in your subsequent application, you have addressed that reason for refusal. What other reason would the caseworker have to refuse? There will be half for the caseworker.
Okay.
But this is not about discretion. This is about checklist. So with visit visas, it's about discretion.
Okay.
But checklist-based decisions is checklist-based. Are you a EU family member? Yes. What's the evidence? Either birth evidence or marriage evidence.
Right.
Do you have a EU national in the UK? Yes. What shows? You have provided a passport of that EU national. Have they been in the UK before the cutoff point? Yes. You've shown the
For EU
letter. Were you a family member before the cutoff, the 31st December 2020 cutoff? Yes. You have shown when you married. If you are a child, then you don't have to show that because you might have been born before that anyway. And therefore, it's not a matter of, it's marriage that you need to show that you married before that.
Okay.
Check, tick. Yes. Oftentimes they will say no. And that's why we say it's a mistake on their part. They may say no because they are looking at, for example, marriage certificate that is issued to you by way of registration of the marriage under 1984, 1884, 1885 customary marriage law provision, where you marry at home and you register with the government.
Okay.
If you marry at home, let's say 1st December, and you registered 1st of January, the date of marriage is not 1st of January, but 1st of December. So if you married 1st of December 2020, you married before the deadline. If you registered 1st of January 2021, the registration was after the deadline, but it's not a marriage. The point is, were you a family member by marriage? Yes. I was on the 1st of January. But the evidence we are bringing says that it was registered, and the word is registered. Then we go by the law. The law and the consideration says that it is not about date of registration of the marriage, but the date of the marriage. And therefore, you may have the registration date different from the marriage date. So some caseworkers do not know the difference. And therefore, to choose between one that is favorable to them, they will go for the date of registration.
Okay.
To your detriment. But you put to them that, no, it should have been the date of marriage, not date of registration, because the law says so. But you misinterpreted the law. And therefore, I'm going to seek administrative review, so review and come back. Or I'm going on appeal at court. Then the judge will make a decision based on the application of the law. Or I will say, you know what? I'm not going to go to court. I'm not going to seek administrative review. I'm going to do it again. But this time, I will tell you that you refused it because you thought the date of marriage is 1st of January 2021. But hey, that is actually of registration. And under the law in question, based on which the marriage was contracted, date of registration is a choice. Date of marriage is mandatory. And I married before the deadline, but I chose to register after the deadline. But it doesn't take away the fact that I married before the deadline. You clarify it for them. And whether it is the same person or a different person, they will see that, oh, so my colleague who made the first decision did not even understand the local law. And therefore, I'm not going to make the second mistake for this person to point it out to us. They will grant. And that's what I mean by addressing the first refusal. For example, you were refused because they said that you did not meet the maintenance. And the caseworker did not exercise evidential flexibility to give you a chance to provide whatever was missing. As I said, minor omission. You don't have money to go to court. You can apply again and address it. Let me give you one example. The wife recently joined the husband with their child. The wife had been previously refused. At that time, she wasn't married. She was coming on visit. She was granted a visa, and that is the point here. Viewers and listeners, there is a difference between refusal and cancellation of the visa.
What's the difference?
The difference is that if the visa is not to be granted, it will be refused. So you know that you didn't get it. But what if you have been given and your hopes are high, and all of a sudden say we are taking it away because we now know that you shouldn't have been given, then it will be cancelled.
Okay.
That's the difference. So refusal is point of decision. Cancellation is after
The
the decision has been made.
And they realize they made a mistake.
Yeah, so it's an afterthought. But why, somebody will say, why afterthought? Because the provisions allow that. The afterthought will always be that it will be picked up at the point of entry. That's why sometimes you'll be granted the visa, and at the point of entry, you'll be asked to go back because they don't think that you met the requirements. Or they don't think that the caseworker who made the decision made the right decision.
Okay.
Have you realized that anytime we travel abroad and we get to the airport, destination port, UK for example, Heathrow, Gatwick or wherever, we go through the queue, we'll talk to the immigration officer, and the immigration officer will make a decision to let us go or to stay.
Ask you to stay away.
Have you thought about that?
That's the entry.
That's the point of entry. That means, yes, we've come, but it doesn't end it because those people at the point of entry are also caseworkers. They're also immigration staff.
Okay, so they make another decision there.
Yeah, so they have to make a decision to let you in or not. So it doesn't mean that you've been granted and that's the end of it. No. The final test will be when you enter and you are on a visit, on a visa. Of course, if you don't need a visa, you don't need a visa. But if you need a visa, then you'll be assessed again.
So before I go to my next question, so there is the point where your visa will be granted, and there's another decision to be made for you to enter.
Yes.
So your visa in itself does not give you the permission to enter.
So you have been given leave to enter.
Yes.
But who finally exercises the discretion to allow the leave?
Is the entry point clearance
entry clearance officer.
Oh, okay.
So we have
So you could have a visa in your passport,
yes,
but you would not be allowed to enter.
Yeah, if they feel that the decision to allow or grant a visa was made erroneously or by mistake.
Right.
So you'll be questioned. And they feel that this question should have been asked and the answers considered. And if the questions had been asked and the answers considered, maybe you would have been refused. Then they will make a decision to cancel it. Refuse your entry and cancel your leave.
Well, folks, we're looking at a situation where your visa or your UK entry clearance is refused, and you think that you cannot do it again once that has happened to you. Lawyer says it is not the situation where you would not be allowed to enter. You can do an application or make an application again, as it said, but you'd have to answer the questions that were posed. The limitations of your previous application would have to be addressed. We are live on BWTV, live on BW Radio, we're live on BWF Solicitors Facebook, YouTube, and all the social media platforms. And my guest and resource person, Lawyer Charles Asma, is coming from BWF Solicitors, our trusted legal partners. And you can visit them Monday to Friday, 9:30 a.m. to 6 p.m. Call them, book an appointment, and go to enjoy that competent service level that they exhibit every now and then. 0208 493 7340 is their telephone number. The emergency one is 077 127 61884. 077 127 61884. Now, we're going to take some questions. I will pose my last one, obviously, but we'll take some questions from the platform, from the WhatsApp messages that I have, and also activate the lines. Remember, the lines we'll be using are two of them: 0208 123 1016 or 07399 208 468. Don't call now. The lines are not active. I'm going to ask for the final question. When I do, I will bring you in. And lawyer will just do the final bit of his presentation. Then we go on to that. I've seen a lot of you put on questions on the platform. Thank you so very much for making that very engaging. And I believe that we will have time to go through all of them as many as we can. Lawyer.
So, Brakuku, the example I wanted to put across to buttress the point is this. This is a live case where it happened. Now, as I said, the person has arrived to join the husband. Mm-hmm. Before that, 2 years ago or 3 years ago, the person had been refused. They were given the visa in Ghana, entered the UK, landed Heathrow Airport, was questioned and was returned.
Okay.
What was the question? They are saying that you applied to visit the UK and you said you have £14,000 equivalent of local currency in your bank account. And on that basis, they concluded that you are able to meet the cost of your trip and come back because you are okay. Mm-hmm. Now you have arrived at the airport and we have asked for your bank statement, your bank balance, and we can only see £2,000 equivalent. Why the difference within a short time? Does it mean that you only presented to get it? And now, thinking that you are coming home. Unfortunately, the person couldn't answer. So they said that we don't think that you are coming on holiday and you have adequate means to afford the trip. Mm-hmm. So got married, then the husband made application to bring her. So in the application, I had to check the refusal. So always you have to point it out to the lawyer that I've been refused before. And if you have the refusal letter, give it to the person. And if you are doing it yourself, consider the original refusal. So the person gave it to me. I read it and I said, okay, that's fine. So this is what we're going to do. We had to address that refusal conclusion in the cover letter as part of the additional information. So he said that previously this person made application, was granted, but the application, the visa entry, the leave was cancelled and returned. At that time, the immigration officer concluded that 14,000 reduced to 2,000 means that she only created the account for the visa purposes. Right. But we want to point it out that that is not true. And the actual reason for the reduction or shortfall is this. She is young, very looking forward to life ahead, considered investment, bought land after acquiring the visa, worth about 10,000 pounds, equivalent local currency, reducing the balance from whatever it was to this one. And therefore, at the time she arrived at the airport, the balance is obviously down.
go out.
So not that she didn't have a reason, but she was confused because of how the sort of the nature of the questions put to. So she explained, but she couldn't put her point across. But actually, this is the fact. Actually, this is the reason. Actually, in any case, she's not visiting this time. She's coming to settle. Husband with the child. Husband has met the requirement, blah, 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 blah. Therefore, it must be granted. It was granted.
All right.
It was granted. So what I'm saying here is this. Being refused previously doesn't mean that you will not be successful the second time. It is how you approach the second application.
Doesn't matter how many times you are refused.
It doesn't matter, but again, it matters the passage of time before you make the second application.
If it's too quick in succession, then
for example, visit visas. If you are making that every month, so desperate to visit the UK is good. UK is the best country you want to visit. But why couldn't you pause? Or why couldn't you give up? Why couldn't you try somewhere else? Why are you so desperate to visit? There's no case law or there's no statutory provision or policy guidance on this. But it's common sense approach the caseworker will take. So what we are saying is that we have to make it also difficult for the person or the caseworker to apply the common sense approach to conclude with a way to in their own favor and against us as applicants. So if you are coming on holiday, for example, first you said that you were on leave. You are making application again. Are you still on leave? If you're on leave again, you have to address it.
Address it, yeah.
You made the application, you say you were coming for training. Are you still coming for training?
Is the training period not even
Exactly. You made the application, you say you were visiting your family member who is graduating.
The graduation is
the graduation not over? Are you still going on graduation? The reason might be different, then you have to address the new reason and why it's different from the previous one and why they cannot put the two side by side and conclude.
So obviously, there is the chance for you to succeed when you have been refused and you're doing it again. You have to address the reason and provide the rightful answer. If you are in doubt, I would ask you to consult a lawyer, as obviously my lawyer friend would have advised you. And my recommendation will be BWF Solicitors, our trusted legal partners when it comes to the law. And obviously, when we are in the community and we want some trusted people, it's BWF Solicitors. Visit them on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, N15 4NP postcode. Call them on 0208 493 7340 or 077 127 61884. Now we're going to go to the interaction segment, and we will be asking you to get in your answers, your questions and concerns. We'll be addressing them. The number to use via text is 07950 You can send in your WhatsApp voice note, or you can call in 0208 123 1016 or 07399 26 208 468 right after this. Okay, welcome back. So we go into our interactive segment, and I'll first of all go on to a voice note. But lawyer, one feedback from somebody who earlier, I think it was last week when we were on, she came in with so many questions about her accommodation. Um, she wants to move out of the accommodation. The estate agency, they will not allow her to do that because she signed a contract, but she's giving them evidence that she can't pay, so she has to move. A friend is,
we should email her.
yes, and I am happy to say that she heeded to your advice, and there is a solution. I have specifically asked her to come and tell me the story herself because it sounds better.
We thank God.
Naomi, good afternoon.
Good afternoon, Papa.
That is a
Mipachayo now.
Nyame mboko. Your story is a testimony and a feedback to lawyer Charles Asma. Then is here. What did you do?
Mipachayo Babakachi. Like
Then now we have solution.
Mipachayo media program Saturday. Man, me kwa juma. Ana me boy try me employer.
Mhm.
And the manager, a family business into no manager no. Ana otro into no ma. Letting agent for no.
Mhm.
The Ochon Monday, Wednesday, no more say affidavit. So I'm saying, person me too. I'm charge me early termination fee,
Mhm.
which is 240. And I'm manager and can't okay, no problem with you. And you call more, it's not a sure. I hope that yeah, for your own good because we cannot debate here. Cannot person when yeah, I'm not court.
That's right. Yeah.
I'm conscious court will ask a senate so catch them soon to me and man. Muna bill to know. I hope there was mutia then or yenita and I'm counsel or more tears.
Right. Is it say what 12 February out, you know?
And not my rent this month in a version 24.
Okay.
That's why yeah.
Na sanka o money and then cry and come very fund those kind of money.
Almost 10 years.
Okay. So the lawyer can you know only when you run no ekasa mo letter the command letting agents now. Now they haven't relieved you of the contract because obviously your circumstances have changed that you can't pay. Yes, sir.
Me pacha.
Mo I did. I mean inshallah. Lawyer.
That's
Well, congratulations.
thank
I mean,
you.
you see, the whole essence of this program is to offer what we call independence and hope to viewers and listeners. Somebody caught in that web or situation didn't know what to do. The opportunity created through the program gave her the hope and gave her independence to pursue her own course. She didn't have to go to a lawyer, but of course, where necessary, she would go to a lawyer. But then she knew this time what she needed to do. She pursued it, and thank God she's gained or received solution. Today, she's talking to us happy. Previously, she was confused and not sure what to do. The difference between the two is what this program brings.
Right.
So if you are seeking enablement, you are at the right place and on the right platform.
Naomi, CP, and thank you for being bold enough to come back to let us know. So thank you very much. Right. Congratulations.
Me that so me that
Thank you. So Naomi is a testimony of the enablement as lawyer mentioned. Yeah, well, another voice note was has, so let's go to that quickly and into lawyer but over to you send the text 207-504-22780. Let's pick that up. This
Morning, Patrick February may apply for visa. Medibetro exam UK, but may adwuma and any salary. But sika ɛwɔ me account
Let me start.
morning, Patricia Medas Bibri may apply for visa the bachelor exam UK, but may adwuma and any salary. But sika ɛwɔ me account nti me supported the whole nti me supported trip no nti me indicate say me ma me na sponsor ne nyinaa nti in that situation no who be sɛ still me de me bank account ɛbɛka ho say me ma me ne bank account no ɛyɛ okay.
Okay. She's saying evidently that she has scheduled exams, but the institution will not write a sponsorship letter. She's being financially sponsored by the mother who lives here in the UK. Can she personally write, or the mother write this letter, or she herself will have to write a letter that the mother is sponsoring her? In that case, does she need to add her personal bank statements to the fact that to that, because the mom says she's fully sponsoring everything?
So the mother who is the sponsor will write a letter showing the sponsorship. So letter of support, or letter of sponsorship, or letter of funding or finance.
Right.
She will write a letter explaining how she will finance her own travel. Because it's her case to prove how she will finance. And the third party will support to confirm what she's saying. So she will write a letter. You know, in the visa application that she'll be making, there will be a box asking for additional information. So she can provide that information in that box. How she's going to be financing this trip.
Okay.
And the mother will write a letter explaining that she will be supporting the daughter's trip. The daughter coming, blah, 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 for X number of weeks or days. And she will be meeting her accommodation, her flight, and her stay in the UK. And she's got bank statement to show that she's got pay slip to confirm that she's working, and therefore she's earning.
Okay. All right. 0739920848. Thank you, Naomi. We've got yours, and our sister who sent the voice note to you, we've got yours as well. If you have a text, I am waiting for it. Let me go to the platform. I think there are a lot of them there to pick up. Let's see which one we have first, and we'll pick that one up. Nana Bob. Nana Bob, you say that you have a friend who has settled and has applied for settlement visa for his 9-year-old son in Ghana. It was successful last week. She needs to go and bring her son, but due to her being a single mom of 2, she cannot travel. She's planning to let the airline or the air hostess bring the child, or let a family member bring him. Please, the question is, would it be possible for someone aforementioned to bring the child? And if so, what due process needs to be followed? And number 2, if the child comes and spends 1 year on his indefinite leave, can the mom register the child for British passport, though the mom have settled status and don't want to apply citizenship by herself? Well,
Okay, so the first part, and that's something that a lot of people can relate to. We do receive calls that, oh, lawyer, my people are coming, I cannot go and accompany them. Can they come alone? It's a matter of flexibility. If you cannot come for good reason, write a letter, send it to whoever will be bringing the children. But depending on the age, they may not be, or it's 1-1. So depending on the age of the child may not be able to come unaccompanied. I'm not sure whether any airline crew member will be willing to take that responsibility.
previously, I knew some airlines were doing company finance and they were bringing them in, but now they have, I think the cutoff year is 14. So until the child is 14, he or she cannot travel all by himself or herself. They don't do it anymore. I don't know why.
So that is why I said I'm not sure. So as you have pointed out, that one is up to the person to find out from the airline if it's possible. However, if there's somebody traveling to the UK and the person is willing and able to bring the child, you give the person authority, mandating the person to bring your child. And with that, the person will be able to bring the child. Since the child comes in terms of passport, well, it's not a case of passport, it's a case of child becoming a British national or registering the child. I don't know how old the child is, but granted, the person is a child. So the person once comes in will have to, doesn't matter whether the mother has citizenship or not. What the mother needs is the, what do you call it, the indefinite leave to remain or the settlement that has been mentioned. Now, if the mother has settled status or indefinite leave to remain, the mother will register the child. As we pointed out, the rules have changed recently, and therefore, once you come from abroad and you are seeking to go for your nationality application or to register to become a British citizen, you have to, of course, have indefinite leave to remain yourself. And again, with this child, I'm sure the child will be granted indefinite. But again, if the person mentions settled status, it tells me that this person is a EU national. So with EU, you'll be given entry clearance. And once you enter, you have to make application for pre-settle. However, because the mother has settled status and the child is still a child, the child will be given what the mother has.
Okay.
So the point we are making here is this. I would suggest that let the child come into the country.
Right.
That's step one. Once child arrives, we make application to get the child the settled status. Because child will have to move to step two. And from there, we'll discuss step three.
Okay.
Because if you are going to get step one, step two, step three, all mangled together or up, the person asks just that you take it a step at a time. Child can come through somebody if the person is willing to give the child, give the person a letter. When the child comes, if it is under EU provision, as you have pointed out, application should be made for the child settled status to be issued. Then from there, we'll look at what next.
Okay. 0739920848 or text or WhatsApp to 0795042278. Now let's go to the platform and pick another one there. This one is from Covenant Grace, and Covenant Grace says, please, is it possible to make leave to remain application using direct access as a father with child arrangement or contact order only without letters from the child's GP and school where there is disagreement between the parents. There is disagreement between parents regarding emergency contact at school and GP. Covenant Grace puts in the question, lawyer.
Right. So the reason why somebody will rely on the court order is that the mother may not be willing to support the application. The mother of the child may not be willing to support the father's direct access application. So if there's court order, then that concludes the matter that the person has proven that they have direct access to the child. Because within the child arrangement order, there will be, of course, as it is in the name, there will be arrangement as to how often the father sees the child. So it will show that the father has direct access to the child. And if it is, the person will need that court order. However, you cannot just use it because you have access to the court order. You need permission from the court to be able to send that to a third party, which is the Home Office.
Okay.
So that's what I want.
Right. I have a call here, and hopefully we'll stay on. I think it's coming from Ghana. Hello.
Hello, good evening, Chief.
Good evening, boss.
Good evening to me Pacho you. Me Pacho, me question me come a lawyer.
Okay.
Me passport. Me month of birth no. A different from the original documents. That's me best set. But medical year application, UK. But you refuse me that. But recently I realized this. But the refusal reason in here because of my date of birth no. But recently I realized the passport, date of birth instead of June, The 5th of July, no me in June. Me pese me funny as if me maintaining the passport. This one I submit my affidavit to correct the mistake. And you say my question here clear.
Is he on the line?
Yeah, he's on line.
Okay, hello, good afternoon. How are you?
I'm fine.
Good. So you say that the month of birth is entered in
Yes.
your passport by mistake.
Yes, it's instead of July, they made it June.
So it is entered by mistake in your passport.
Yes, please. And I've applied to UK without
Let's deal
making
with
any.
my questions one at a time.
Okay, please.
So the passport office might have made that mistake, possibly.
Yes, please. Yes, please.
Okay. Now your birth certificate suggests is July,
Yes, please.
and that is the correct one.
Yes, please.
And you use the passport, this passport issued in error with respect to your date of birth to make a previous application.
Yes, please.
Right. Obviously, if you are going again and you are using passport and the birth certificate, it will show inconsistency. So in your application, what
Yes,
date of birth did you put in your previous application? Is it the passport date of birth or the birth certificate date of birth?
that is the passport date of birth. Passport date of birth.
And did you add your birth certificate the last time?
No, please. Birth certificate wasn't requested.
So you feel that birth certificate, maybe you may use the birth certificate. That's why you want to see if you have to correct it.
No, I'm not getting it.
What I'm saying that to me, nobody knows that there's birth certificate with July. To me,
Yes,
everybody knows
yeah.
that your passport has your birth
It's
date
June.
of birth, which is June.
Yes, please.
But what makes you think that this is not true, that you need to correct?
I'm thinking maybe in the near future, if I should make an application, maybe they might request for my birth set.
Okay.
And
right. So you are thinking ahead.
Another fear is my mother has gotten her pre-status. So maybe in the near future, if she should make application, probably yes, please, yes, to prove yes.
But if
yes.
you are proving that you are your mother's son, and it's true that you are the son, you can use DNA, can't you?
Yes, of course they can. Yeah.
And if you use DNA, maybe you don't have to use your birth certificate.
Oh, okay. Okay.
No,
Okay.
Do you agree?
Yes, please. I do agree.
But DNA will do the work of the birth certificate.
Oh, all right. Oh, okay.
So what it means is that if you feel that the date of birth in your passport after your third thought is actually true and your birth certificate is actually wrong, then keep your birth certificate in your date of birth in your passport, but do a DNA so that it will confirm that you are the son of your mother who may wish to bring you over.
Maybe as a follow-up question, boss, the line and to lawyer, he might have realized that the passport office made a mistake, which he can approach them to correct. Would it be prudent for him to do that correction now in anticipation that it may come up as a question later on?
In that case, yes. However, he will also need a letter from them to confirm that they made a mistake and it has been corrected upon alert.
Okay.
Otherwise, it will appear as if he's just changing passport, nilly-willy, just to suit himself.
Okay.
Okay. So if they have made a mistake, then you have to let them show that they made a mistake by way of letter, and to say that they have now corrected it by way of issuing a new passport. Then you keep that letter with a new passport so that you can always use it if there is issue.
Okay. Is that clear?
Okay.
So you have two
yes,
options.
Please. Thank you very much, Mr. Rico. Okay.
All right.
Okay.
Thank you, and thank you for joining us.
God bless you.
God bless you too. He joined us from Ghana. Okay.
Thank you.
Another one let's pick one from the platform. Let's see what we have. This one is from Kevin Asamoah. My friend made an application to bring his children to join him here in the UK 3 months ago. Can he contact his lawyer to pay for the fast track or wait for the Home Office to notify his lawyer before?
So the children are here.
Mm-hmm.
I don't know what visa the children are on. If it is either way, the children would have been given what they ought to be given. If it's under EU provision, the children are in. You don't need the Home Office to do anything. All you do is apply for the pre-settled or settled for the children, depending on what the parent has. And if it is under Appendix FM, once the children arrive, they'll be asked to pick their cards and suggested are in from wherever post office they have identified. So those are the things that he has to be aware of. But I don't know specifically why the Home Office and the lawyer and all. I would say the question is not clear. But if it's a matter of they want to apply to extend the visa for the child, then you don't need permission from the Home Office.
Okay. Well, if you could provide further clarification on that, thank you very much. Kenneth Ofori Boateng, Abtubam, thank you for joining us. Just go and do a new birth certificate, bro. Anyway, I told you that when you come and join the platform, because it's so exciting, conversation there is really pretty good. 0739920848 or 0795042280. Naomi, asking me to ask you a question, but I don't seem to get the question. There's a text here, you say, ask me a question. If you could pose the question again, that would be brilliant. I would appreciate that. Can we pick another from the platform? Okay, before then, let's pick up this call, 0739920848. Hello?
Hello, good afternoon, Ola and Layata.
Good afternoon.
Good afternoon.
Yeah, this is Kelvin. Lawyer, my question wasn't clear enough, isn't it?
Yes, it wasn't.
Exactly. What I meant was, my friend is here, and he has applied to bring his case from Ghana.
Is it under
And
EU
now
or
we
under
know that
Appendix FM?
under EU board.
EU. Okay.
Yes, and for the priority service, the Home Office said that you can pay so that they can fast track your document.
Priority service
Yes.
from
Can you contact?
Ghana.
Yes.
Oh, so the child is not here yet.
No. But the priority service Home Office just wrote that you can pay more so that they can fast track your decision.
So the application is still pending, yeah?
Exactly.
Yes, so Home Office has started doing that. It's one of the wider scheme of expanding cash flow net. So, yeah, they will write to you asking you that if you want to fast track it, you can fast track it. You pay the money. However, there is a provision. So read it to the end. They will tell you that if your case is still complex, they may still not be able to meet your fast track request. Then in this case, you still have to wait.
Oh, okay. You were thinking that you can contact the lawyer that.
No, read to the end. Then you make a decision whether you are happy to wait, because you pay the money with the expectation that they will fast track it, only to be told that we have assessed your case and we think that it is not to be fast tracked on this occasion. But they will refund the money. Are you with me?
Right.
So let the person think through that. But if the person thinks that everything should be as it is, then yes, they will pay and it should be fast tracked. But I want you to understand that there is a caveat. They have put a cross there.
Okay. Right.
So the answer is yes. They can give it to their lawyer to do it for them, but they will make a decision for the lawyer to carry out that decision. Okay?
All right. Thank you very much.
You're welcome.
Okay. All right. Thank you, Kevin. God bless you. 0739200468. Hello?
Hello, Riku.
Yes, sir.
Good evening.
Good evening.
Yeah, my name is Joshua from London.
Joshua, you sound a bit far away.
Can you hear me now, Rico?
I think it's better.
Okay. Rico, I have one question. I came in on Appendix FM, and I came in March, but
March 2022?
no, March 2018.
2018. Okay.
Yes, but when I renewed, my date went to November.
Okay.
So what I'm asking is, can I have my application, definite application after March, or should I wait for November?
So is it on a call?
Yeah, it's on the call. Yeah.
So if you say your date came as November, what do you mean? Is it a date on the letter or date on the card?
The date on the card on the renewal.
So what is the date on
When I
the
renewed
letter?
after the date on my original, the date. I mean, I came in.
You were given pre-settled, weren't you?
No, I'm on Appendix FM.
Oh, sorry, Appendix FM. Okay, so 2.5, is it?
Yeah, so my first 2.5 years was in November. So when I applied, I had another November. But actually, my 5 years will be in after March.
So you, in your view, your 5 years is due by next month.
Yes.
But there's another thing to also suggest that you have to wait till November.
Yes, the card that I have expires in November.
Okay, but what does the letter say? Is it March?
March. Yeah, I came in March.
No, it's not when you came in. The letter that, when you were given the visa, you were given a letter that shows that you've been granted. Then your card was issued to you.
So the original letter is 31st March.
So the original letter says that the visa decision was made or the visa was granted March. The card was issued later. So if you are looking at where to use it, you have two options. If you use March, you have a case. If you use November, you have a case. Because card is issued after the visa is granted. And if you are calculating your timelines, you start from when the visa was granted.
Yes.
So the visa was granted 31st of March, then you count from that point.
Okay. All right.
Right. To be able to, is it on the 5-year route?
Yeah, 5-year route. So it means from end of March, I could put in my application at any time if I'm ready.
So if by end of March you've done your 5 years, but your card has not expired, the card will expire later. You have a choice, and then you have to address it in your application that my card expires on this date. However, my visa was granted on this date, and therefore 5 years ends on this date. Therefore, blah, blah, blah. Are you with me?
Yeah, I'm with you.
So you point it out to them so that they are clear.
All right, that's fine.
Okay. All right. Thank you very much. Let's pick one from the platform. And this one says, ask lawyer about my children from Ghana through their dad, as he said he's not getting the indefinite leave to remain for my children. Is there any way I can get it for them? They have stayed with me for 3 years. They were in the UK.
So, I mean, if we analyze our member's question, I don't know what it's here. So, okay, so our sister's question. So, brother, okay, children came from Ghana through their dad. The dad is saying, no, I can't continue. But they are here living. So, did they come to live with the father and the mother, or they came to live with the father? That is something to be considered. And did they come under Appendix FM or Appendix EU? Who was the sponsor?
Okay.
So these are all important questions. So say that if it's very, very, if it's the case that you want this to be taken up, please call us and let's ask further questions so that we can conclude on the best advice to offer you.
Okay. One here is saying, okay, let's put this on the platform quickly, and we go for a call and come back. My second question is, can someone who has pre-settled status bring children who are 37 years and 28 years to join?
So somebody who has pre-settled status is a national, a relevant person. What it means is that the person is a relevant person under the EU provisions. If they have dependent children at home, they can bring them. Because they are over age, quote to quote, and the relevant age is 21. Because they are over the age, they have to show that they depend on their parent that is seeking to bring them.
Okay. Well, let me go to the lines. I have somebody on there. It's very busy. I text line today. Hello. Good afternoon.
Hello, good afternoon.
Yes, sir.
Yes, sir. I just want to ask a question.
Go ahead.
About the Home Office fast track applications. Does it apply to?
Hello.
Then they will pay and it should be fast tracked. But I want
your
you to
line
understand
line
that
is pretty
if-
bad. Can you
So,
slowly
who has
speak
pre-settled
and come again?
you that they depend
Application.
Hello. Hello. Okay. Try and call us back. Unfortunately, we missed your call. I think the line dropped. There's one here. It says don't mention my name. Put it on the screen, so don't do it now. But I'll read it. It says I've settled status. It will be 1 year in October this year being granted. I'm hoping to apply for naturalization in October this year due to the change of character requirements, even though my 10 years legal residence will be in December 2026. All right. It says my name. Home Office has accused me of marriage of convenience in the past in early 2016. I went to court on this but lost. This means I'll need to wait till the full 10 years, or can I try my luck? I have no issues with character for 6.5 years now since I was granted my Zambrano in December 2016.
So this person has settled status after whatever issue they claimed they had. They have been granted settled status on what? Because the point I was going to make was that if they accuse him of marriage of convenience and he succeeded through whatever means to get the leave granted, settled status granted, then it appears that they have reconsidered the decision they made.
Okay.
Otherwise, I want to know how he managed to get to this point. If they accused him of X, Y, Z, and so he was denied, how did he sail through? And that would be a point for consideration moving forward. So it might be that there are other few things that he would necessarily not want to share.
The person sent something that says, no, I didn't succeed.
So how did he get the settled eventually? So let him call.
You're listening to us, so if you could. I later applied for Zambrano and was then granted. So obviously it's the same thing.
So applied for Zambrano, and this time based on a child.
And was granted.
Was granted. So I mean, when we say suitability, yes, you said I am that my marriage was that of convenience. I couldn't prove it, so you concluded that no to me. But here anyway, so it wouldn't be a matter or a case of suitability per se. Because if I say A and you say no, you disagree with me, it doesn't affect my character per se. unless it's actually the case that, but I mean, how do they conclude? They can only conclude by law, but the person wasn't able to defend fully. That's why they were able to win the case. But if the person was able to convince fully, they wouldn't have. So that shouldn't help affect the suitability argument.
Okay.
Yeah, it shouldn't affect suitability argument. So he can, yeah, go ahead and.
Oh, okay. Well, let's pick this one on the line. Hello. Hello.
Went up.
Sorry. Let's start all over again. Hello.
Okay, hello. 'Cause I want to know if the Home Office fast track system does it work under EU settlement scheme?
Oh, okay. The fast track, the EU settlement scheme. Do they have to go through anything?
I mean, the fast track system, they make reference to family applications. So Appendix FM applications. So, and what I will also say is that it's not a case of going to do a fast track. They will request you to do it. So if they have requested you to do it, then so be it. If they haven't requested you to do it, then usually they will send an email, just like the one who called. They will send you an email too. So I'll say that wait for the email to come through. But what they pointed out is that if you have made a family application and it is still pending, you can go for fast track. They will email you and you take steps.
Okay.
Okay.
Okay. All right. Thank you. Yes, let's go to the platform again. Pick up a few. 0739920848. What are the requirements? My second question is, can someone who has pre-settled status bring their children who are 37 and 28 to join? Is there any set of requirements for that?
Well, so you have to prove that they are your children. You have to prove that they depend on you for their essential living needs. 37, 28, they are of age. So why are they still depending on you? They have to prove it. Why are they not able to be independent? They are. You've got to prove it. How do they? So depend on you, cut across, not just money, but everything in terms of emotional support and all. So the key thing is dependence. You have to prove that they depend on you.
Okay. I've got voice notes. Let's quickly pick that one up and go on with it. We still have a few more minutes to do our interaction. Then today, I think we would have time to get on to the quiz segment. So here we go.
Okay, me pato nkwala no mu Ghana me sister nkyɛn by papa ne bibi ɛyɛ awale. Sisi a me se wanya ne indefinite, I think getting to 3 years now. Na no wo issue kakra nti no nkwala no deɛ me na kɔfɔ ɔmo kora free Ghana baeɛ. And since ɔmo baeɛ no, me na me ne ɔmo atena, ɔmo nnim ɔmo papa ne fie da, ɔmo nnim ne fie kora mpo yɛ, ɔmo nnim baabi a papa no kora ɔte. Nti since day one a yɛenter UK, me na me ne ɔmo atena up to date. But papa no anya ne indefinite no, anka ɛwɔ sɛ ɔgye nkwalaa no deɛ ma ɔmo no, ɔse ɔngye because ɔne me nni in good terms nti ɔngye mma wɔn ho. Ɛno na mpɛ sɛ mehu akwannya bi wɔ hɔ a metumi agye indefinite na ama ɔmo a.
So it means that the kids are here.
On their account.
On their account. Both parents are here, but they're not living together. They're separated. And the man is going indefinite. And she's thinking that they're not transfer to the, but not willing to help. What can she do?
So what does she have? That's missing.
That's missing.
Well,
it's not a live call.
If you are listening, please call us. Yeah, okay. Call the office and book to come and book to speak to us or book to come and see us. There might be certain points that we have to pick.
Okay.
And if we can put the pieces together, then we'll look at the best way to help the children. Because the question is, how do the children get through this situation?
Okay. Yeah. All right. On the line, we have somebody. Hello.
Hi. Lawyer, I put in an application for naturalization last year, August, and I understand the waiting period is 6 months. To be honest, we're in February now.
Line
In
is a bit
February,
patchy.
kind of nervous. I don't know because I've not heard from them. I don't know.
You know what? Let me. I can pick your number. Let me call you back.
Okay.
Yeah, it's a bit patchy where you are. So let me just pick it up and call you back. Um, okay. Hopefully we'll get through to him. It's not a call I want to lose. As much as any other person's call, I don't want to lose that. Hello.
Yeah.
Uh-huh.
Yeah. So
Yeah, the same
was
person.
like,
All right, this is better.
Okay.
I applied for naturalization
Mm-hmm.
last year, August, particularly on the 17th, and it's been more than 5 months. Kind of a bit person. I don't know. What it is. I don't know. So any advice for that for me?
Okay. So your application is delayed.
No, so I think they said the OT period is 6 months,
So your application
and
is delayed.
no, I'm within the 6 months, right? It's past more than 5 months.
You made the application and the decision hasn't come. Is that what you are saying?
Yeah, for naturalization.
Well, you made the application, the decision hasn't come.
Yeah, the decision. Yeah,
And you think that it's more than 6 months, isn't it?
but it's not yet 6 months now. Then I think it's gonna be 6 months. It's 17 February.
February, so it's not yet 6 months.
Mm.
So what's your actual question?
My question is, I'm kind of only left with about 2 weeks to 17th, and what do you call it?
6 months.
For 6 months. So kind of a bit. I'm worried. I'm nervous. I don't know.
All right. You know, nerves are everywhere with us. Even the weather is making us nervous. So I can appreciate that your application will make you nervous. I don't think you have to be nervous. You have to eat, drink, relax, wait, and pray for it. Okay? It will
Right.
come. It will
Yeah.
come. If you think that it's delayed beyond reason, send them an email that you said you do it 6 months or this time. You haven't done it. I want to know why. Okay?
Okay. Oh.
Did you do it yourself or a lawyer did?
I did it myself.
Yeah. So it doesn't matter who did it. If you feel that you can't wait any longer, write to them. If you think that it is not up to the time they have to finish the decision, then wait with me. Okay?
Okay. Oh, thank you very much.
You're welcome. Enjoy your
Cheers.
evening.
You too. Yeah. Right.
Okay. Right. I think the person with the 3 children is sent in another voice note. We see how we can help.
Brako mpacho me no me wɔ 2.5 through me British child. Me third time na me wɔ mu no. Ti sɛsi a deɛ mekita ne sɛ ewu a na merekɔ fourth one no a mede bɛkɔ akɔgye indefinite.
Okay. So 2.5 on the 10-year route.
But the children, did they also? I'm not sure
Was
whether
it
the children.
through a British child? So let's assume she has a British child, isn't it?
No, the children, the children we
three
are
of them.
discussing, the ones that came from Ghana through their father, who abandoned them, so to speak. Not sure what they had when they entered, whether they were given, because usually they would have been given indefinite leave. But if they were not given indefinite leave, what were they given? So
So
those
we need to
pieces
find
are
out.
again.
Okay.
So,
So ideally, I would
yes,
recommend
it has
that
to, yeah.
report at the office, and lawyer and the team would be gracious enough to to address your issue. So you don't have a problem.
Yeah,
Last
there
time
should be a way out for
we had a solution for another situation. So this shouldn't be a problem at all. Hello.
Hello.
Yes, sir.
Hello. Good evening.
Good evening.
Good evening, Kwaku. Good evening, lawyer.
I do.
I think I'm a bit late, but anyway. My first
No,
question
better
is
late than never.
never. Is this program only English, or can I speak in my dialect, please? Because I prefer speaking my dialect with
No,
my.
go on, go
I
on, go
prefer
on, go
them.
on. Worry at all. Go on, go on. Feel comfortable.
Okay, okay, okay. Well, that's my
Did you
official
have me uncle why?
Me pacho question here, lawyer me pacho me pese me who say yes say obi kura British citizenship na yeah 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 different in somewhere oh yeah yes
But I
dear
want this so kakra why?
me pacho me say yeah father to be a British citizen
Uh-huh.
na ebia bibinti later on they came to realize that ɔkye yɛ no na problem bi wɔ ho ɛna ɔhema different in nsɛm after some years bi wɔ hɔ a obetumi apply biom anaasɛ ɔntumi apply for the passport no ɛwɔ wiase mu biom mpakyɛ mo question no na
Yo, say yen ya can ask me or the whole room ha.
mepakyɛ ɔwɔ ha a
Into then or
ɔwɔ krataa fra wɔ ha
okra bibi and what
ɔwɔ
have you wa.
indefinite leave to remain ɔwɔ indefinite leave to remain
So we into our starting process bibi sanity.
mepakyɛ ayɛ wasate
Into
biribiara no
our
ɔwɔ
starting class 1. Let's say we do form 4 or kwen nim.
indefinite.
Into be we are now graduate. So graduate no still ano you who be fufura. No asan ko start bi. Yeah, so he's within the journey. When he will then apply again for naturalization. Then the process
All right.
continues as before.
Okay then. Yo. And then the major answer may how can you?
Oh no, wait a minute. Yes, I can
Oh,
say.
question,
Fabra.
Obi from Ghana, messing up with you.
Yo.
Okay. All right. And that's it. 0739920848 and that's over send the text 0795042278. Hello.
73992.
Can you go off the volume of your radio set and speak to us on the phone, please?
Yeah, evening.
Good evening.
Yeah, I'm calling from Scotland.
You're calling from?
Scotland.
Can hardly hear you.
Calling from
Yeah, I'm calling from Scotland.
Scotland.
Scotland. Okay.
Yeah.
Okay.
Yeah, my issue is that. Hello. My issue is say, me a school, we go to na my IT and Oma Ball, and the visa say only the one.
But bit me to when chance ever be. Also school.
Go school Scotland.
Okay.
Like
Me and my school.
I am masters.
Okay.
Yeah, me about me
We Abba.
yeah. Visa now the buy. Yes, you want to me Juma. And I'm pretending that we do one more to
I but man I age.
about my head now.
Right. Until no more can say engagement. Omo can say many year juma and say many year ejuma bi.
No work. You see, no work, no business. Then I'm sorry.
Okay. So no work there, no work. That means you can't officially work. The word is you officially work. Officially. Why?
Question is he is here as a student.
So that's why I was surprised that he was the person that she was given that condition. But usually the student dependent will not be restricted to that extent. Sometimes they will say you cannot do certain jobs. But she was restricted wholly.
Does it help?
Yeah, no.
It's a bit. How many months have you got to go on the leave?
Oh, the leave is ending in January.
January 2024.
Yes.
Right. I mean, depending on your strength, and
Yeah.
you can consider switching her
Two.
to something else.
Okay. Okay.
So you can consider switching her to the skilled worker route
Okay.
because she is
Okay.
not a student. As long as she
Okay.
has a visa, she can switch.
Yes.
And if she
Okay.
switches to something that will allow her to work, then that will resolve that
Okay.
problem. Um,
Oh,
if you can, so Brakoku will give the number, the studio number. If you can share a copy of the card with those conditions
yeah,
at the back.
yeah. If
Yeah,
you
do
want
you have the
to
text? Do you have a
send it
text
to
and
me.
WhatsApp number?
Yes, I
Yes,
text you just some few minutes ago.
Okay.
yeah. So
So
later, then
later on, share it and
you can
I'll
add
pass
your
it on.
number. Yeah, it will be passed. We will look into it.
Okay. Yes.
Okay, it's one of those unusual cases,
Cases.
but
Okay.
it is what it is that they said the person cannot work.
Okay. So please provide us those further pieces of
But did she
information.
say she was coming to join you, or she was coming to visit like holiday, just coming as on holiday?
No, she said she was coming to join her husband.
And they have indicated a dependent, a student dependent.
Yes.
Right.
That sounds a bit strange.
Yeah.
Okay.
Okay.
Provide a detail, and a lawyer would have a consideration on that. Give you an advice on that. Right?
Thank you very much, boss.
Okay. All right. Let's pick up these comments quickly. Do you need to have your British passport stamp if you travel to 3 different EU countries in one day? The same person poses the next question and says that, do you need, okay, it's the same thing that's been put on again. So,
Do you need to have your British passport stamped?
if you travel to 3 different EU countries in one day,
I don't know whether the person has tried it and they have stamped it. But there's no specific law on that. What I do know is that post Brexit, if you are EU, if you're a British national, you can visit EU countries, visit, and that the word is visit. You cannot go inside there, but you have 90 days to go stay there for fun and return. But I don't know whether they stamp at the airport. But even if they are stamping it, they are not taking it. Let them stamp.
let them stamp, and I'm going to put a stamp on the questions I'm going to pose. We're going for our quiz segment quickly, and we'll be right back after this.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-221 Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, now going to my quiz segment, and to all my friends on the platform, thank you so very much. You've been very wonderful. I know the interaction going on is so exciting. I wish I was there rather than sitting in the seat hosting, so I could enjoy that. But let me go to this question, and it says Mary applied for a visa to the UK as a spouse of a British citizen. To meet the eligibility requirements for maintenance, she submitted 5 months back statement showing that her husband earned £2,000 a month, that is £24,000 per year, per annum, as they say. She was required to provide 6 months pay slip, 6 months bank statement, an employer's letter to confirm his employment and salary of at least 18,600 a year. The application was refused. She was given a right of appeal against the decision. What may be the outcome of the appeal? She does it. The appeal will be allowed because £2,000 multiplied by 12 months is 24,000, which is more than the 18,600 required. 2, the appeal will be dismissed because she failed to provide all the evidence required. And 3, the appeal will succeed because under the evidential flexibility rules, the ECO, that is the, what will be the ECO?
Entry clearance officer.
Entry clearance officer should have given her the opportunity to provide all the evidence. Now, do I give you a clue of the answer? Because I have discussed it this afternoon. But let's see how many of you will get the answers right. Go onto the platform, put your answers there. Let's do that quickly before we go. I know those of you who will be on BW Radio, the news will be at 6, but maybe Lawyer will give you about a minute or two extra to get that through. So let's see, what answers do we have? On the platform, you can put that one on or send a text 079504222780. The appeal will be allowed because £2,000 multiplied by 12 will be 24,000, more than 18,600 required. The appeal will be dismissed because she failed to provide all the evidence required. And 3, the appeal will succeed because under the evidential flexibility rules, the ECO should have given the opportunity to provide all the evidence. Okay, now let's pick the answers now. The first one. Oh, okay. If you are listening and I want to text, that's one. That's fine. So what would be your answer? Is anybody coming? Okay. Now, before I go, I will want to, let's see if we can pick. Okay. Abdul Ademununkum, sorry. Ademununkum says 1, which is the appeal will be allowed because £2,000 multiplied by 12 months is 24,000, which is more than the 18,600. But read it. It says that to meet the eligibility requirements for maintenance, you submitted 5 months of bank statement. But what was the requirement? Provide 6 months of bank statements and pay slips. Okay, let's see what other answers we have after Ademununkum. Kwabena Santi says number 1. Kwabena Tufo says number 2. Rebecca Marco says number 1. Okay. Kwabena Tufo, you change your mind. Oh, okay, you've come again. Number 2. Says number 2. You're so convinced it's number 2. Okay, now let me go back to the main platform and see if I can do that. Okay, bring Maiti has joined us quickly, so we're going to have her on, have a little chat. We're going to talk about the English language and the preparation for the teachers scheme that is also coming up in a short while. Maiti. Good afternoon. Hi.
Good afternoon.
Summer is gone. Summer is gone.
I know, but Oreku, why anyway, me try to phone you. Yeah, Pachana will be some as a man to honor.
I know a English language for no any yes, say teacher for they not but almost one better English.
Almost on metro ethics, no. On metro English, no, but some more degree. We had a meeting yesterday, but nanka omo contemplate says denka omo degree no degree crowd betro. But I think say yeah, consult to home office no, they are saying say no. So with degree na or qualification and the bit me a degree no ethics no na or the application. So yes, yeah, ɔmbɛtumi use so. Nti no, ɔmbɛtumi only been so you have to write it because some of the teachers no they have the qualification but they haven't been to university because ɔmo colleges no ɛnyɛ ne nyinaa na those time na ebi mo di kan yɛ na ya convert into the university level no first no na dodo na it was just the first you can say training certificate ne nko a nti no in per se no o convert no a it's not up to the degree level nti no sɛ wowɔ ɛno nko a old student ne bi na wowɔ ɛno nko a there you still have to write the ethics but sɛ wowɔ degree no and you have the qualification ne there you don't have to write the IELTS sorry you don't have to write the IELTS wobɛtumi use ethics no na wode ayɛ patro menim sɛ ma answer question a
Oh, okay. And in this situation, no, so only English now. Katie at consult, move to me about the English now. And what will be the average pass mark?
Yo, meda soreku. You bet me Katie for bet me a more more quite be brave. So and yet just even the English, the whole package, ye very soon, ye home webinar within this week. And I actually quite our be fast so from the scratch to the end. It is so be our interest or ye teaching ni no a person also embarking on this new program. Yeah, Katie for bet me abwa. Yes, and we can also help with the IELTS preparation. No, a no we try. And way past mark, I think it's up to 5 cry. Okay. And we have may listening in an amid ababe to board and also at the ama 84.
Okay, all right. So in due course, Katie will be able to support people to write the English language, and also to give you advice as to how to go about with your application. But you're waiting at Maya and Katie, the contact details, Nibio.
Okay, Katie, if you want to contact Katie at Consort of Wa, and one say you can either send an email to katie.edconsult@gmail.com or you can call or send a message on this particular number 075-966-20-154, and Katie will be there to support you from the scratch till you get here. We are collaborating with some of the schools that got the sponsor license, and they are giving us the procedure or the process that they want to use in collaboration with the government scheme to recruit these teachers from especially our country, because that's where I want my people to come from. So if anyone is interested, yes, Katie can support them throughout the process. Thank you.
Well, now Maya T is my co-presenter on the program. You can catch her live every Friday morning between 9 and 11 a.m. on Legal Hour. And she normally does that with the senior partner himself, Ben. Yesterday was another very wonderful one. I know she had questions that were left there that supposed to have come in there, but unfortunately, time and tide waits for no man. And nah, unfortunately. Okay. Are there a few answers, Professor Day? If not, then we'll go to do our conclusions. Now, don't go away. Kevin Asamoah says number 2, the appeal will be dismissed because she failed to provide all the relevant documents or the evidence required. There's a question. Well, unfortunately, we've run out of time. We've gone 4 minutes past the hour. La, let's see what answer there is to this question. Very interesting question.
Very interesting. Oh, yes, go ahead.
It borders around the nugget we brought and discussed earlier
exactly.
on. I wanted to give people the clue, but that would have been too easy. Okay, let's hear you.
So, Rako, we're going to work through this and the last minute classroom interaction. So,
I'll be the student.
No, you'll be the professor.
I'll be the professor.
I'm the student put on the spot to present to
the
teacher. Right. So, sir, what
can we go to where the nugget is, and that will help our discussion. Okay.
So, sir, what you taught us is that the law is there and the Home Office guidance is there.
Okay.
The Home Office guidance says that if you are making an application, you must provide a specified evidence.
Mhm.
If you provide a specified evidence and there is a minor omission,
Okay.
then you may be given a chance to bring that minor omission. But that means that, say, if you don't bring the specified evidence and you think that you'll be called to bring them, they will not call you to bring them. Now, from that information,
Let's go to the question.
our sister Mary knew that she needed to provide the specified evidence to show that 18,600 is met.
Mhm.
Thankfully, she has 24,000. She has to bring evidence of pay slip to show that
6 months of
6
that.
months. She needs to bring a letter from the employer to confirm that she's actually working, to corroborate the pay slips.
Mhm.
She also needs to bring the bank statement to confirm that the money actually comes to her. 3 specified evidence. Our sister Mary forgot the 2 of them and only sent part of 1. So even if the caseworker wanted to exercise discretion to allow the evidential flexibility rule, the caseworker could only consider the bank statement which had a minor omission. However, there are 2 of them that were left out completely.
Mm.
So she was supposed to bring them, but she did not bring all of them. And because not all the specified evidence were brought, our sister Mary will struggle to succeed under evidential flexibility rule as a means to argue in court.
So the appeal will not succeed.
So the appeal will not succeed because she failed. And the key word is all the evidence that were required.
Okay. Well, those who were saying number 2, I think you learnt very well. And the answer to this week's test is number 2. The evidential flexibility rule requires a measure of discretion on the part of the caseworker. Discretionary powers are not unfettered powers. They can be challenged in court. So the appeal would not succeed, but you can still challenge it, and you have to argue your case out. The Home Office guidance confirms that decision makers are able to grant an application despite minor evidential problems, but not where specified evidence is missing entirely. And they have a general discretion to request additional information or evidence before making a decision. They said bring 3. You brought only 1. And 1 was not even complete.
And even the 1 wasn't complete.
1 was not even complete.
So even if we're considering to give you marks, they will say, hang on. 3 questions, you didn't answer 2. How can we score you?
My sister Mary, your appeal will not succeed. Anyway, on that very interesting note. Now, any word for us before we go away? Once you are on, obviously I'll bring you on. So
I know. I know. I have a slight problem with one of our students. I've tried everything possible to even form a simple sentence for her to construct that particular sentence or repeat after me, so that in case we having an interview with her during the exams, exact words she will be able to say. But unfortunately, our mom here, it's around 59 years. And if I should give an example, like how are you, the name, and then her response should be, I am fine. I've tried several times, then just the simple statement, I am fine, has become a problem. All that she could say is, I'm fine. Oh no, I fine. You don't even hear the you hear I fine, I fine. And we've practiced this for like a week, and it's still I fine. The woman can say I am fine. So such a thing, lawyer Asma, when we have a problem like this, how do we what would be the further support that we can give to this woman? I leave it to, I'm not asking you to give me the answer, but situations like this, I just want to let the public know that we have time, we have patience to teach everybody, no matter what the standard. And I believe if it were you, probably you would definitely know I am fine and not I fine. So if you want Katie to support you, we are here to do so.
And I also want to say that that is a broader approach to ensuring differentiation. Every child, every student, every learner matters. And the KT approach is one that the government actually looks for. So, Katie, you are on point.
Thank you.
And anyway, it wouldn't sound right, but I was going to say, nah, how are you?
I fine.
Okay, thank you. But it's understood.
It's understood.
That's the point I wanted to drive at. It's understood that you have people from other nationalities who have different accents or they have their sense of English appreciation, but still they are integrated in the community and they can communicate and exist. So people shouldn't give up. There is support, as KT is giving. There is support to get you over the line so you can pass certain examinations that you would have to write. So thank you very much. Laura, I think it's now time for your final bit. Then I will say my goodbyes. We have another wonderful week for us.
So, viewers and listeners, we have looked at a case in point that if you have ever been refused visa or ever had your entry clearance cancelled upon entry to the UK, is that the end for you? We have concluded that no, dependent on your peculiar circumstance. The only point where it will be difficult for you to try again and succeed within a short time is where you were refused or your visa was cancelled because they have found out that you were granted the first visa based on false representation, and therefore, if they had found that out, you wouldn't have been granted. Or at the point of decision, they found out that you used false information or evidence or document, and therefore they refused you. And because of that, you have also been banned from entering the UK for at least 10 years. If it's a case of being banned because of that, then that would be difficult for you to reapply within that 10 years and have the visa granted, because the provision is that the caseworker will always make reference to that ban and it has to be taken off before you can move to the next step. In that case, you have to make an application for the ban to be removed or to be revoked before you can proceed in future. Otherwise, you have to wait for 10 years. And even when the 10 years has expired, it has to be still removed. So you have to make an application for it to be removed. Otherwise, if you have been refused before or had your visa cancelled, you can try again. The reason why it will be refused is that you have not met the eligibility requirement. And the reason why it was cancelled will be that even though the decision was made to grant you, it was later found out that you did not meet the requirement, and therefore decision is made to cancel and to refuse. And this is within the policy and within the law. So under Part 9 of the rules, and also under Part A3, paragraph A3, and Appendix EU rules, caseworkers have the power to refuse and power to have visas cancelled if later it is found out that the decision to grant was made in error. And what we have also said is that if you ever have a chance to reapply, make sure that you address the reason for the refusal so that you put your application in context for them to make an assessment based on this present application. Even though the caseworker is required to make the decision based on the present application, it's important that you make reference to the old one and the reason for refusal so that they appreciate that you have done your work properly and this time everything is set out properly. This is what we have considered today. We believe it's been useful to you and friends and family. Once again, do join us again next week. Thursday, Friday, and Saturday, when we bring you joy, knowledge, and enablement. Been a pleasure. Thank you.
Well, it's been a pleasure. It's been an exciting experience this afternoon. And we have had Lawyer Charles Asma doing so much justice to the question we posed. The question posed and the answer is yes. When you have been refused, it's not the end of the story. Life continues. Do it again. Do the right thing. Answer all the questions and you'll be granted again. We also had Nama T joining us, and the good news is that there's another opportunity with slots for you to come into the UK to work, especially as teachers, and also there's support for people who are having challenges with learning and also writing the English language. KT Educational Consult will help you with that. And on that note, I want to say thank you to my studio director and producer, Professor Ade, for his excellent work today, and also to Sheila and Padmore for that wonderful bit of work they did behind the scenes, to Uncle Ben, to Lawyer Richard, to Lawyer Eunice, to Lawyer Charles Asma, to Lawyer Patrick, to Debbie, and all the wonderful members of the BWF Solicitors family. I say thank you to all of you. And to you out there that listened and also participated live on the various platforms, thank you for sharing, thank you for liking the page, and thank you for even deciding that you'll be coming back again to be with us on another edition same time next week. My name is Kufri Paul. Thank you. Have a good week.
Yeah. Jesus, you're my everything, yeah. My everything is you, Lord. Yeah. Oh, oh, oh. Oh, oh, oh. Everybody say, ah. Oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not